This is Kathy Humbarger in the studio with you. Thank you so much for tuning our way today. I think you're going to enjoy the next few minutes we spend together as we learn more about the complex and intricate court system and the legal arena and how it impacts our advocacy for the unborn. Our guest today is Jim Holden, an attorney and member of the Indiana Right to Life Board of Directors. Jim, thank you so much for joining us.
Well, thanks, Kathy. I appreciate you having me.
Well, you could spend your time in many ways, I'm certain, Jim. Why did you decide to accept a seat on the Indiana Right to Life Board? And what motivates you to be about this business of life?
Well, I've always been pro-life, but I think it's incumbent upon attorneys, people who practice in the legal system, to take a step beyond just their day job and get involved in efforts to make sure that the law is fairly and justly applied. I believe that the judiciary has gotten way out of control in its activism towards the pro-abortion side. And I think it's important for those attorneys who are pro-life to get involved and ensure that the courts are about the business of interpreting the law and not making the law.
Well, that's something that we want to unpack a bit as we visit with you this morning, Jim. But before we move on to take a closer look at the courts, tell us a little bit about your role as an Indiana Right to Life board member. I would assume that your legal expertise is something that's very helpful to the cause at the state level, and I understand you work with other attorneys as well.
Well, that's right, Kathy. Of course, Indiana Right to Life is the premier organization in Indiana that's looking out for the rights of unborn children, especially in the public policy arena, looking to not only change current law, but also look at ways we can use the current law to our advantage, use the existing regulations and restrictions on abortion in Indiana to our benefit and for the benefit of unborn children. So I think it's important when Right to Life looks at those issues to make sure that we have some attorneys on the board, and we do. And it's my particular project as kind of a spin-off of the board, a subcommittee, if you will, to gather some like-minded pro-life attorneys to discuss ways in which we can use the current law to our advantage in this movement, but also to use our knowledge of the law and the court system to promote the pro-life view.
And I think our listeners would be very encouraged to know that some of the brightest and best legal minds in the state of Indiana are very pro-life and helping us to kind of sort through this the legal opportunities that are in front of us. So I wish every listener would have the opportunity to meet these folks, because it is a very good group of folks that are going to help us make certain that we do everything we can to defend the unborn in the state. Well, let's take a minute to look in the rearview mirror and remember how this attack on life began in the courts that culminated in the Roe v. Wade Supreme Court decision on January 22nd, 1973. Jim, many legal experts contend that this decision was bad law. Do you agree?
Absolutely. And even in fact, many lawyers and judicial commentators who are not pro-life and who don't agree with you or I about the need to protect the unborn even agree that Roe versus Wade is a bad legal decision on its merits and should be reversed. And I think that's definitely right. There's many reasons, but two that occur to me most obviously. First, the Roe decision is really just one step in a long series of decisions prior and since Roe that have created so-called rights out of thin air that the Constitution never intended to create. In this case, a federally enforceable right for a woman to have an abortion contrary to state law. Before Roe, the states had the exclusive right under their general police powers to pass laws protecting unborn children, and in some cases criminalizing or prohibiting abortion. Roe's, I think, biggest problem is that it ignores the state's inherent right to regulate in that area and upsets the separation of powers and our federal system of government, where the states have all rights to regulate in areas where the federal Constitution doesn't give the federal government the right to regulate. And in this case, the federal government gives the federal government no right to regulate in this area. And I think any high school civics student will tell you that the federal government is a government of enumerated rights, and the federal government doesn't and shouldn't have any more rights than the federal Constitution grants it explicitly. And the federal Constitution includes no power for the federal judiciary to take this move. The other thing that I think is very disturbing, other than the Supreme Court creating what it calls a penumbra of rights that aren't in the Constitution that it's going to infer, such as the right to an abortion, but Justice Blackmun, in writing his decision, goes to great lengths to point out that abortion has traditionally been regulated, even going back to ancient Greece and Persia, to cite examples, and then says that it's not the job of the judiciary to decide when life begins, but then goes on to write a decision in which he presupposes to know and sets this artificial viability versus non-viability standard to determine basically when life is worth protecting. And I think that's a very fallacious argument.
Well, it seems to me that there are many who want us to believe now that Roe is settled law, and since there's no appeal to the Supreme Court, we're stuck with it. Do you agree?
Well, for the time being, it's certainly difficult to see a way in which we're going to reverse it overnight, but I do think, like many Supreme Court decisions, like the Dred Scott decision that upheld slavery in the 1800s, the court does reverse itself. They usually don't admit that they're wrong in the process.
And it's kind of a chipping away process, is that what you're saying?
It can be, and it can take the form of adding new justices, obviously. Of course, as you know, Kathy, there's a movement in Congress to pass a human life amendment to the Constitution to deal with this, but of course that would require pro-life majorities in the House and the Senate that we just don't have right now. But Roe, like many other past Supreme Court decisions, is not unassailable. It'll just take a lot of hard work. And unfortunately, the mood in Washington is probably moving in the opposite direction, at least for the moment.